This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Welcome to the Sunday morning tradition of the Church of BARD. Gary, how are you today?
I'm great, Mark. How are you?
Very good. Very good. Good to see you. Happy to be here. And, there's so many things we could talk about. We haven't continued our comment of the week. There wasn't any that kind of hit the.
We really need a special one in order to keep that going. You know, we'll hit it. We'll hit it when it's warranted.
Okay, good. One of the things that was interesting, it wasn't on, for those of you who don't think we do any research, we actually do, but one of the stories that we hadn't put up on the board, so to speak, that is interesting is that there's a judge, I believe his name is Ho, who came out and gave a speech at I believe a Federalist Society meeting or presentation, and said that given the cancel culture at Yale Law School, I don't know how many of you are following this story, but at Yale Law School, there's been a controversy, I guess, for lack of a better term, about some of the speakers and if you hew too far to the right or conservatives, there apparently there's a backlash to actually having you present at the school or engage at the school. And his suggestion was that he will no longer hire clerks from Yale Law School. You seen this?
I have. It wasn't. I would not disagree with you, but I wouldn't even call it a suggestion. He outright came out and said the quote was, "Starting today, I will no longer hire law clerks from Yale Law School, and I hope other judges will join me as well."
Yeah. So, which is an interesting. Yeah. If you dig down into that for a second, like one of the things that you might say is, well, what if I'm one of the so-called victims of this cancellation at Yale Law School? How did I know when I was applying to a Ivy League law school that a couple of years down the road I'm going to lose a coveted clerkship by virtue of me attending this school at the time? So as most things, there's a counter argument that seems to be pretty prevailing.
Yeah, absolutely. And exactly to your point. I mean, it takes several years to get through law school, and the political and, cancellation landscape has changed wholesale, I would say, in that time period for someone who may have started 2 or 3 years ago. Yeah.
And so it isn't just in the law, by the way. And we talked about this with Adam the other day, and I just sent you something. Do you have the Gavin Newsom letter to the Assembly? Here you go. So we have a bill here that.
This is the bill, Assembly Bill 2098, that we've spoken about on various Corolla Digital shows, including this one. Adam and Drew have spoken about it because Drew is understandably very fired up about it. And this is the one that, as Drew frames it, just basically makes it illegal to speak to your patients in any way that is not towing the state of California's government line as far as COVID-19 goes. And I was reading this statement that you sent me from the Office of the Governor, and there was one line that just really stood out to me. It's in the second graph. I'll just read the whole thing for us. I am signing this bill because it's narrowly tailored to apply only to those egregious instances in which a licensee is acting with malicious intent or clearly deviating from the required standard of care while interacting directly with a patient under their care. The required standard of care? Suck my dick. Are you kidding me?
Go to the next paragraph.
To be clear, this bill does not. This bill does not apply to any speech outside of discussions directly related to COVID-19 treatment with a direct physician-patient relationship. I am concerned about the chilling effect other potential laws may have on physicians and surgeons who need to be able to effectively talk to their patients about the risks and benefits of treatments for a disease that appeared in just the last few years. However, I am confident that discussing emerging ideas or treatments, including the subsequent risks and benefits, does not constitute misinformation or disinformation under this bill's criteria. Well, Drew disagrees.
First of all, let me tell you what it does do, which I haven't heard. Maybe you guys have discussed it. Specifically, it invades the physician-patient privilege.
Yes.
Because it specifically by its own terms only applies to the communication between a physician and a patient. Who's going to have the right to monitor your physician-patient privilege, which is not only evidentiary, but a statutory and a consecrated privilege. There's also HIPAA violations as well as to what are you going to do? Tell the patient, what did he tell you? You got to tell me what he told you, or tell the doctor, you got to waive the privilege and tell me what you told the patient. This thing, if it wasn't so frightening, it's almost comical in terms of how poorly drafted it is, how idiotic it is, and how it just is plainly, when you do constitutional analysis, you can say, is it constitutional as written, or is it as applied? In this case, it's both. It's unconstitutional as written, and there's no way to apply it. I mean, there's on its face, I would think that a physician challenging this, who would have standing, anybody who, a doctor who treats COVID-19 patients presumably would have standing because he's in fear now as of, the reason I put the letter up is because it was September 30th. So as we tape this, it's only 48 hours old and effective. So starting tomorrow, if you have normal office hours for a doctor, you have your speech threatened and chilled. And that's, by the way, that's a First Amendment issue. I'm more concerned with how do they get away with intruding on the physician-patient privilege?
It's hard to really understand when you've got the president of the United States, the leader of Gavin Newsom's party, walking around the Detroit Auto Show now 2 or 3 weeks ago, telling 60 Minutes the pandemic is over. And then you've got this. Is this just purely a campaign thing for him? It's hard to really understand because, yes, there's just no way in which you can understand this to be constitutionally valid.
I suppose this week we'll probably see somebody challenge it. That would be my guess. Nobody's going to. I mean, if you're a physician and you're treating COVID patients, what if you're just an ER doc? What do you do at that point? You're afraid to even communicate with your patient because somebody's going to have the ability. What I want to know is, how do they think they're going to get in to the physician-patient privilege if neither one of them cooperates? If they just say, you can't force me to reveal my communication, then what?
And I don't think that it's these days. I don't think that it's too far to think that somebody who believes that it is just and righteous would try to seek out doctors and get them to say things and then go report back and try to get these doctors in hot water. And what's this going to do to your medical malpractice insurance? If Drew advising a patient on what he thinks is the best course of action can be a situation where he's being come down on by the state of California, just, over a third party report of it, this doctor told my mom this, and then all of a sudden he's defending himself in court. It's not going to work. It doesn't work.
Well, there's also another issue. Why do they think whoever crafted this bill that limiting it to COVID-19 makes it less susceptible? Because that's what the governor is basically saying in essence, right? Is because it's very limited, that therefore it's he's willing to do it, and it won't get to a point where where we're challenging science. The problem is that I think, and I've talked to Drew about this obviously, but science is not. The whole idea of science is not accepting what conventional wisdom is. That's the opposite of science.
Absolutely. I mean, it's been a real problem throughout the pandemic and possibly before, but it's been highlighted through the pandemic where people talk about established science. Science is not established. There is the science we know today, but science is constantly challenging itself and constantly evolving, and new science comes out every single day because that's the way the scientific process works. Go back to 7th grade and think about how you were taught the scientific process. It's impossible to have established science. I mean, especially in a field like a pandemic with a disease that is 2 to 3 years old and changing at all times.
I don't understand it, and apparently it passed unanimously or close to. So that speaks volumes about whether it's a political pandering as opposed to something that you may want to seek out over misinformation. And this idea of misinformation is a scary, scary thing. Well, we had one or two more stories I think we can still get to, Gary. Yes?
Yeah. Which one's first for you?
I'm going to let you pick first.
All right. So we teased a few stories, but one that we haven't touched on in a while is that of Tom Girardi and his ongoing, situation with his law firm and the trustees that have become involved in the bankruptcy and the now, I believe it's nearly $500 million that his firm owes to various clients. And at the middle of it is his wife, Erika Jayne, who I'm well aware of because my wife is a fan of those shows, and I'm not, but I spend time with my wife, so I've seen a little of it. And she's trying to shield herself from having to give back a $750,000 set of diamond studs, which, damn, those must be pretty nice.
I think from an Armo jeweler, too, if I'm not mistaken.
Well, that would make sense, absolutely. So she's basically going back and saying that they were a gift. It was in 2007, and therefore it's beyond any statute that might allow for this to happen. But the trustees coming in and going, I have receipts here that say it was paid for with law firm money. Those are ours. Give those back. Yeah,
it's interesting because that case, you've got so many fronts that are being waged. I mean, there's originally the Edelson firm out of Illinois who was on the airline case with Girardi, who's the one who actually discovered this. I don't think people recognize that it wasn't any intrepid reporters or anything like that. It was the co-counsel in Illinois. Then the bankruptcy proceeding, and the trustee has been kind of doing a scorched earth, if you will, to find any and all assets. And one of the things that they found were these earrings that you mentioned. And there is a good argument, however, I think, and it looks like, even though this is taking place under the bankruptcy court, and the other federal court in Illinois is not completely separate, but it's a separate proceeding. What they've done here is her lawyers have filed in federal court to say that every conceivable statute of limitations has been blown, right, and you can't just go back ad infinitum. Frankly, I think it makes all the sense in the world. If you're talking about 2007, that's just absurd that you're going to be able to claw back or have anybody be able to defend against for something like that. So he makes a good argument, or she makes a good argument, and it'll be interesting to see whether the federal court gets involved or whether they just kick it back to bankruptcy court and say, let the judge there decide.
Yeah, absolutely. And I thought it was interesting that in her filing, she points out that the gift in question of the diamond stud earrings was to replace diamond stud earrings that had been stolen from her a few years prior. I don't know what that was intended to do, maybe tug at the heartstrings, but I did think it was interesting that that was included. All right, one more that'll just be sort of a little side dish here. I found it very funny that Gavin Newsom vetoed a bill that would forgive parking tickets for homeless. He's all for the homeless unless it's taking money out of his pocket. So pay up, homeless.
Whoa, it's interesting, and remind me to ask Adam about this, because this really fits in with a couple of Adam's theories, right? The empty bag versus
I couldn't agree more. The taxpayer, the taxpayer motoring down the road versus the empty bag. That's why I wanted to do it as a little side dish, because I'm sure we'll get into it on the early best hour in the universe this week. We're going a little earlier than even the last 2 weeks. So we're looking forward to that.
When are we doing it this week?
This week we are doing, you and Adam are going on someone else's show on Tuesday morning, and then you're going to hang around and we're going to do the big show from the studio right after that. So that'll be Tuesday morning.
Perfect. Well, I thank you for carving out some time this Sunday. It was great.
Pleasure. My pleasure.
And let's see some good comments, okay?
Absolutely, yeah. Light us up in the comments, and we'll highlight you when we get a chance. Mark, thank you again for your time this morning.
Thank you, Gary. Bye-bye.
Bye-bye.
Thanks for listening to Beyond a Reasonable Doubt. Stay tuned for more bonus episodes coming soon.